Hello and welcome back to Immigration in Focus. I'm Maria Aguila, immigration attorney with Florida Immigration Law Firm. And today I have three major immigration changes, a lot to unpack in a 15-minute podcast. So I'm going to try to do my best. But major immigration changes important to mention: electronic filing rule, tougher approach to adjustment of status that came out in May with regard to what we call extraordinary circumstances, and a brand new case law for those traveling under advance parole. That decision just came out August 13. So, with that, I'll go ahead and get right into it. So, part one: USCIS is now moving towards mandatory electronic filing. On August 10th, 2026, USCIS announced that the Department of Homeland Security is introducing an interim final rule that will allow USCIS to require electronic filing for certain immigration forms. The rule became effective August 11, 2026. Here's the important part: USCIS may eventually require electronic filing of an immigration form once that particular form has been made available for electronic filing for at least 180 days. That does not mean that every USCIS form suddenly became electronic only on August 11th. Instead, it just created a framework allowing USCIS to make electronic filing mandatory on a form by form basis. USCIS says it will provide the public with at least 60 days notice on its website before making any electronic filing mandatory for a particular form. So applicants, attorneys, petitioners, you need to pay very close attention to the USCIS filing instructions. A filing method that is acceptable today may become unavailable in the future and may certainly change. Under this system, filers will generally use a USCIS online account. Depending on the form, that may involve completing the immigration form electronically or uploading a PDF of the completed form together with supporting evidence. USCIS says there are several reasons for this transition. One is efficiency. It can reduce their dependence on physical lockbox operations and paper files, reducing errors and incomplete submissions, and potentially shortening processing and decision times. Cost: moving away from paper processing and physical lockbox services could create significant savings for the federal government. And third, and one of the most important parts of this USCIS announcement, is for national security and fraud detection. USCIS says electronic information is easier for the government to receive, store, search, and analyze. According to the agency, faster access to electronic information can improve identity management, fraud detection, and national security screening. In practical terms, we are watching USCIS becoming an increasingly digital immigration agency. An even more important development: there is an online filing available for the I-485, application to register permanent residence or adjust status for certain applicants and their representatives. For qualifying online I-485 filings, they also permit certain related forms and evidence to be submitted also electronically. So that means that attorneys and applicants not only will increasingly need to understand immigration law and all its changes and policies, but you have to really know their electronic and their basic filing procedures. One technical mistake, uploading the wrong document, using the wrong filing method, missing any evidence, or failing to follow the latest instructions can create serious problems. There is some relief built into the new electronic filing rule. USCIS states that people who cannot file electronically may request a waiver based on undue hardship, but these waivers are discretionary, meaning USCIS will determine whether the circumstances justifies an alternative filing method. The public comment period on this interim final rule runs through October 13th, 2026. So the takeaway from this first announcement is very simple. Before filing any USCIS application or petition, check the current filing instructions. Do not assume that because you filed a particular form by last year or heard your friend or family did it last year or even several months ago, that you should file it the same exact way today. Part 2. USCIS announces a restrictive adjustment of status policy. Now, this policy came out May 22nd, 2026. USCIS issued a news release announcing a new policy memorandum concerning adjustment of status. So I'm just now talking about this as an immigration attorney. We were all waiting to see how this all plays out, what kind of questions they'll ask at the interview, how this will affect processing of preparing and filing adjustment of status for those who are eligible to adjust status who entered legally into the United States. So I'll explain a little bit what adjustment of status is. It is a process through which certain eligible individuals who are already inside the United States can apply to become lawful permanent residents without completing the immigrant visa process at a U.S. embassy or consulate abroad. By contrast, consular processing generally means completing the immigrant visa process through the Department of State at a U.S. embassy or consulate outside the United States. So USCIS's May 2026 announcement uses very strong language. Here's what they say. They stated that individuals seeking adjustment of status generally must pursue consular processing outside the United States and characterized adjustment of status for affected applicants as an extraordinary form of relief, with officers instructed to consider the relevant circumstances on a case by case basis. USCIS specifically discussed people who entered the United States temporarily, including individuals in categories such as students, temporary workers, and visitors. According to USCIS, temporary admission to the United States should generally remain temporary and should not automatically become the first step toward permanent residence. This could have enormous practical consequences depending on an individual's immigration category, history of immigration, and the particular legal provisions under which the permanent residence is being sought. So, this is where we need to be very careful. Do not hear this announcement and automatically conclude that nobody can adjust status inside the United States. Immigration law contains numerous statutory categories, exceptions, special provisions, and fact specific requirements. USCIS itself continues to maintain Form I-485 procedures and currently states that certain eligible applicants can file the I-485 form online. And currently, you can file it by paper still. This is why immigration cases cannot be evaluated based solely on a headline. The correct question is not simply, can people still adjust status? The better question is, under what legal permission or provision am I seeking permanent residency? What is my current immigration status and immigration history? And how does the current USCIS policy apply to my particular case? What we're seeing as immigration attorneys at the actual USCIS interview, let's say it's a marriage-based adjustment, they are now asking additional questions. Why weren't you able to adjust status or to consular process versus adjustment of status? What factors that did you consider, or what factors apply to your adjustment of status application and why you were not able to consular process? So that's just an example of how they're approaching this particular extraordinary form of relief for adjustment of status. So, why is consular processing a potentially major issue? This distinction matters because leaving the United States is not necessarily a simple administrative step. For some people, departure from the United States can create significant immigration consequences. A person's prior immigration history, unlawful presence, entries and departures, previous petitions, prior immigration violations, criminal history, or possible grounds of inadmissibility can dramatically change the analysis. In some cases, a person may require a waiver or another form of relief. In other cases, departing the United States without first understanding the legal consequences could create a serious problem. If someone tells you USCIS says you have to go back to your home country and interview, or you can just get a visa and come right back, please do not buy an airline ticket based solely on that statement. First, determine exactly what the law requires in your particular case or consult with an experienced immigration attorney. It's for some people, if they depart the United States and they've been in the United States 1 year or longer, let's say as a tourist overstay, they may then trigger a 10-year bar to reentry. Let me repeat that. For some people who have overstayed, let's say like a tourist visa, and they're married to a U.S. citizen and they're adjusting status, if they depart the United States, even if they have advanced parole, there's a new case law about that, and I'll talk about that in a minute. They could trigger a 10-year bar to reentry if it's been 1 year or longer in the United States as a tourist overstay. So that has serious consequences right there. So, what should applicants do now? Well, number one, do not rely on old filing procedures. Well, I talked to a friend or I Googled it, I saw it on a discussion forum. USCIS is moving very quickly towards electronic filing, and they are also they have new rules in place. Verify what form it must be filled online. And if you are considering adjustment of status, please have your eligibility evaluated before you start making major decisions. Your manner of entry, current status, immigration history, family relationship or employment category, visa availability, and other factors can all matter. Number three, do not leave the United States simply because you believe consular processing is now required for everybody adjusting or wanting to adjust status. Departure can have serious legal consequences. Obtain individual advice before making that decision. Number four, if you've already have a pending case, do not panic. A USCIS announcement does not tell us everything about a particular pending application and how it will be adjudicated. Your individual facts, the applicable statute and regulations, USCIS policy, and the procedural posture of your case all matter. And finally, pay attention to USCIS updates. Immigration procedures are changing quite rapidly, as you can tell from this podcast, and following requirements can change while someone is preparing an application. Now, let's talk about traveling with advanced parole. And this is kind of the third final kind of update I'm going to talk about today. Matter of Del Carmen Lara, issued August 13th, 2026, by the Board of Immigration Appeals. This is one very important development that I want everyone listening to know about. If you have DACA, TPS, a pending adjustment of status application, or you have an approved advanced parole document. On August 13th, 2026, this Board of Immigration Appeals issued a precedential decision called Matter of Del Carmen Lara. This decision changes a rule that immigration attorneys and immigrants have relied upon for approximately 14 years or longer. Previously, under a case called Matter of Arabelli and Urabelli, traveling outside the United States with advanced parole generally was not considered a departure for purpose of triggering the 3-year or 10-year unlawful presence bar. The board has now overruled that rule. Going forward, leaving the United States on advanced parole can count as a departure for purposes of the unlawful presence provisions of the immigration law. Why does that matter? Because if someone accumulated more than 180 days of unlawful presence before leaving the United States, departure can potentially trigger a 3-year bar to re-entry. If a person accumulated 1 year or more of unlawful presence, 365 days or more, and departs the United States, departure can potentially trigger a 10-year bar to re-entry. Just having an approved advance parole document does not by itself eliminate that problem. This is especially important for some DACA recipients who may have accumulated unlawful presence before receiving DACA or during gaps in DACA protection. It may also affect certain TPS recipients on valid TPS, current TPS, and people with pending I-485 adjustment status applications who accumulated unlawful presence earlier in their immigration history. So this is really key important message regarding this uh, uh, brand new case law. So my advice is very simple. If you have advanced parole, but you have not traveled yet, do not assume that that document means it is safe for you to leave the United States. Before traveling, consult with an immigration attorney, review your complete immigration history, calculate whether you have accumulated unlawful presence and are at grave risk of not being able to reenter. If you have a plane ticket already, get legal advice before getting on the plane. If you have pending adjustment of status application, do not assume that this decision means you should withdraw your application or leave the United States. The new issue concerns the consequences that may be triggered by simply departing the United States. There is another important piece of good news. The board said this new rule applies prospectively. In other words, advanced parole travel that was completed before the new decision, which was issued August 13th, 2026, is treated differently from travel occurring under the new rule. So if you previously traveled on advanced parole and returned to the United States, don't panic. Have your attorney review the dates and circumstances of your travel and determine how the decision applies to your particular case. So, the biggest message today at the end of this particular section 3 of the podcast, advanced parole is permission to seek parole back into the United States. It should not be treated as a guarantee that international travel will have no immigration consequences. After matter of Del Carmen Lara, anyone with a history of unlawful presence should have their case individually reviewed before traveling outside the United States, even if USCIS has already approved advance parole. Immigration law is extremely fact specific. Your dates of entry, periods of lawful status, DACA or TPS history, prior immigration proceedings, removal orders, unlawful presence, family relationships, and other factors can completely change the legal analysis. So please don't make this decision based on what happened to a friend or relative who traveled on advance parole in the past. The law has changed. For individual case evaluation, you can contact me, Maria Aguila, at Florida Immigration Law Firm. My office is located at 2318 Park Street, Jacksonville, Florida, 32204. I do have other offices in Orlando and the Tampa, St. Petersburg area. You can schedule an appointment with me at 904-385-9377. So that concludes this podcast. Thank you for listening. If you like this podcast, please make sure to subscribe. And until then, stay informed, stay hopeful, and I will see you next time. Thank you.